Thank you, Mr. Chairman. Thank you all for the witnesses. Very much appreciate your expertise. Mr. Turley, I appreciated your testimony about the threats of Foreign Agents Registration Act being enforced as it may have been originally intended. Many of you mentioned that. In your written statement, you noted, quote, FARA began in the 1930s to combat propaganda and was framed as a way to curtail un-American speech. And when I read that, I must say that my first thought went directly to Judge Ketanji Brown Jackson. If un-American speech was still unlawful today, I'll just note here, there is no way she could be considered as a nominee for the U.S. Supreme Court. I mean, if you didn't see over the weekend, she testified in her post-hearing written questions for the record, quote, I do not hold a position on whether individuals possess natural rights. It's unbelievable. I mean, we can hardly imagine a more un-American position than denying the first self-evident truth of America listed in the Declaration. But I think she's the first SCOTUS nominee to openly hold such a position, but I digress. Okay, Mr. Turley, as I noted earlier, during Special Counsel Robert Mueller's probe, there were at least 5 indictments of conservatives under FARA, and that represents nearly as many FARA prosecutions in just 18 months as there were in the previous 40 years combined. And it would seem these alleged FARA violations were used as either a pretext to investigate those with ties to President Trump, or that FARA charges were used to pressure conservative aides in a bid to find a connection between the Trump campaign and Russia. So no improper connection on the president's part was ever found, obviously, and now everybody knows that was all just a complete sham. But here's the question. Based on your research into the issue and your understanding of the history of FARA, is it fair to say that the law became a highly weaponized tool of the DOJ and FBI against the Trump campaign?
Well, I do think that the Mueller investigation used FARA, as many prosecutors do, as a cudgel to go after some of these individuals. It's a very handy tool. It's sort of like 18 U.S.C. 1001. If you allege a false statement, you get into a warrant, you are able to do a search, you're able to secure information. But particularly with FARA, the concern is that at least with 18 U.S.C. 1001, you have to establish a false statement, and that was involved in the Michael Flynn case. With FARA, these terms are really difficult to track in terms of how they're being interpreted. The Department of Justice itself has withdrawn advisory opinions that, well, at least one critical one, as to the definition of some of these terms. And so suddenly what was interesting about the Mueller investigation is that many of us were familiar with FARA, but suddenly all the lights went on. It seemed like we went from a dead stop to you could throw a stick and hit a FARA violation on every corner in the city. And what really should focus the attention of Congress is not necessarily a questioning of Mueller's investigation, but the consistency of the application of the law and why suddenly we had this emphasis placed on the criminalization and the prosecution under FARA. I have to say that was quite a change from what preceded it. Before that happened, FARA was widely known in Washington as largely administrative process, and the penalty was usually retroactive registration, like what happened with John Podesta.
Right. Okay, so let me get to Hunter Biden. Now, have you had a chance to review the documents contained in that laptop, or at least the publicly available reports on those documents?
I have.
And as the statute currently stands, do you believe that Hunter Biden's activities on behalf of foreign interests, as evidenced by the documents on the laptop, required him to register under FARA?
What I think I feel comfortable in saying is I don't want to presuppose anyone's guilt.
Sure.
What I guess what I would feel comfortable in saying is that with Paul Manafort, if you take a look at what he pled guilty to in 2018, there's obviously very strong similarities in the type of activities that were described in that indictment and what we're seeing in the laptop, including the acknowledgement of the possible necessity of registering under FARA. So if you look at that indictment, that would be a strong basis. If I were his counsel, quite frankly, I'm a criminal defense attorney, I think most people in my position would tell him that we need to be prepared for a charge here if Manafort's is the
standard.
It's standard. But I have to say, all we have are these accounts. We don't know what was presented in the grand jury. My understanding is that Hunter Biden has given information to the U.S. Attorney. So I don't think that we can say with any great certainty that these cases are identical or that a charge is forthcoming. What I am saying is that if you use the Manafort indictment, this does not look good for Mr. Biden.
We all look forward to reviewing that record. I yield back. I'm out of time.